Okay, let's dive right into this explainer. We're looking at what is essentially the ultimate constitutional tug of war over who gets to shape the future of local government. It's a landmark showdown from South Africa back in 1999, a classic heavyweight bout between the national government and provincial governments. And look, while the legal arguments can get highly technical, at the very center of this dispute is a profoundly human issue, right? It's about how we build and govern the actual communities we live in every single day.
So, who really controls your local government? Now, what's really interesting about this question is how it instantly connects an abstract legal dispute directly to us. The fight we're unpacking today isn't about some broad, distant national policy. No, it's about who has the ultimate authority to draw the physical boundaries of local municipalities and, crucially, who gets to dictate how they operate on the inside.
I love this quote from Justice Ngabo of the Constitutional Court. He said, "Local government is the closest government can get to the people." It brilliantly illustrates the reality at the heart of this case. Local government is quite literally the front line of democracy, because it's the main interface for everyday service delivery. The rules governing how these municipalities are established, well, they're of massive national importance. And we absolutely have to remember the incredibly high historical stakes here. We're talking about dismantling a legacy of spatial and economic inequality in post-apartheid South Africa. The urgent need to transform local governance from a segregated past into a democratic future was, well, it was paramount. Past policies left behind massive poverty, gross inequalities in municipal services, and just deeply disrupted environments. So transforming this racially determined system into a democratically determined one was the primary goal of the new legislation being contested here, the Municipal Structures Act of 1998.
Let's look at our roadmap for today. We'll logically step through these 5 constitutional battles. 1. Transforming local government. 2. The constitutional tug-of-war. 3. Establishing the municipalities. 4. Autonomy inside the councils. And finally, 5. The court's final verdict.
Starting off with Section 1, Transforming Local Government, Overcoming a Segregated Past.
Moving right along to Section 2, the constitutional tug-of-war between national and provincial power. So here's where the friction really starts. When the national government passed the new Structures Act, the Western Cape and KwaZulu-Natal provinces argued it was a massive overreach. Looking at this impartially, you have the provinces on one side claiming the Constitution gave them exclusive legislative power to establish municipalities within their borders. Then, on the other side, the national government claimed concurrent and residual powers, basically arguing that Parliament had to pass legislation on local matters to ensure national uniformity. The court had the tough job of weighing these head-to-head conflicting interpretations.
Which brings us to Section 3, Establishing the municipalities or drawing the lines.
Setting up a municipality means you first have to decide its type, so let's cleanly define the playing field so we don't get lost in the alphabet soup here. The Constitution mandates 3 categories. Category A are your self-standing metropolitan areas with exclusive authority. Category B are local municipalities that share power. And Category C are district municipalities covering multiple Category B areas. The national government's job in all of this, simply to establish the criteria for these categories.
Now, this introduces the ultimate independent referee, the Demarcation Board. The Constitution requires that municipal boundaries be determined by this independent authority. And why independent? Well, to prevent political gerrymandering, of course. You definitely don't want politicians drawing lines that just magically include all their voters and exclude their opponents, right? So the board's constitutional duty is to take the criteria set by the national government and objectively apply them to the map of the country, completely free from political interference.
But the specific conflict here arose because the national government's Structures Act actually tried to give the national minister the power to apply criteria and fix what they called nodal points to declare metropolitan zones. The court looked at this and agreed with the objecting provinces. They determined that allowing a national minister to fix nodal points unconstitutionally interferes with the Demarcation Board's independent function. Simply put, it's the board, not a government minister, who must strictly apply the criteria to the map. Let's shift to Section 4, Autonomy inside the councils. Who really runs the show internally? Once a municipality is established on the actual map, it obviously needs rules to operate internally. To make this concrete, the Structures Act set very specific numerical limits on councillors. We're talking a maximum of 90 for local or district councils and a cap of 270 for those massive metropolitan councils.
The provinces argued this was total overreach. They demanded the autonomy to decide their own size and how to organize their internal working committees without being forced to use mandatory mathematical formulas handed down by the national government.
However, the court looked incredibly closely at the exact wording of the Constitution to resolve this. Yes, the Constitution gives municipalities the right to elect executive committees, but, and this is a huge but, it explicitly adds the phrase subject to national legislation. Because of that specific phrase, the court ruled that the Constitution expressly permits national legislation to provide frameworks and criteria for these internal municipal structures. So, while the national government couldn't draw the geographical boundaries, they were perfectly within their constitutional rights to set the menu of options for how those municipalities are internally governed. So, in this particular battle over internal autonomy, the national government won. Let's unpack how this all wraps up in Section 5, the court's final verdict, or the referee's decision. The court didn't just throw out the entire Structures Act. Instead, they essentially took a scalpel to it, brilliantly striking down specific sections that overstepped the constitutional boundaries of national power. Sections 4 and 5 were removed because, as we discussed, a minister cannot fix nodal points. That is strictly the Demarcation Board's job. Section 6.2 was struck because it gave the minister discretion on management areas. Section 13 was removed for forcing guidelines on provinces regarding which type of municipality to establish. And finally, Section 24.1 was struck down because the national legislature itself, not a delegated minister, must set the term of office for municipal councils. The key takeaway here is that the rest of the Act survived. And this proves that the supremacy of the Constitution actively protects the geographical and institutional integrity of every single level of government. The court demonstrated that the Constitution sets up a very deliberate, careful division of labor. The national government sets the broad criteria, the provincial government chooses the specific types to establish, the independent board draws the actual map, and the local municipalities govern within that framework. No single sphere of government is allowed to usurp the role of the others. I want to leave you with a final provocative thought to ponder today. When power is balanced perfectly between national, provincial, and local levels, when the Constitution acts as a strict referee keeping the national government out of local boundaries and protecting local governments from provincial overreach, who ultimately wins? Well, it's us, the citizens, because a system with rigorous checks and balances ensures that power remains closest to the people it actually affects.